My lord, the Kotak Municipality Corporation collecting double taxes for the same services towards the different taxes. My lordship, we are challenging clause 9, 10 and 11 of the Kotak Municipal Corporation Parking Space Regulation 2016 and also challenging clause 12 of the Waste Management Bylaws 2017. My lordship, we are paying holding taxes for the service of road, drainage and improvement of the drainage and also solid management by the way of holding taxes.
But why have you waited for 7 years to challenge this? This is a 2016 regulation.
My lordship, the petitioner has no knowledge when the matter was stood. The BMC, one of the organization, has filed before this honorable court and passed one order bearing by WPC number 11885 of 2016. The matter stood.
No. So till now you are not unhappy with this. Suddenly because BMC regulation has been struck down, you have woken up. You have to explain what were you doing for 6 years, sir?
I had no knowledge, my lords.
Who is I? Not you as a lawyer. There are two petitioners here, sir.
Petitioner has no idea about this fact and imposing.
Association and
how can you have
Association.
If something is there for 7 years, you are paying the tax, right? Are you paying taxes for the last 7 years or you are not paying?
Yes, my lords.
Then how can you not be aware?
It is the burden of the petitioner to give the different of the payments, more than 50,000, my lordship.
No, but why? What were you doing for 7 years? This is a regulation of 2016.
Yes, my lord.
What were you doing for last 7 years? Why did you not challenge it?
My lordship, the petitioner had no knowledge, my lordship.
How can it not have knowledge, sir? You're paying tax. How can you say I have no knowledge? Are you paying the tax or you're not paying the tax?
My lordship, paying.
How can you, despite paying the tax, how can you say I have no knowledge?
I came to know that holding tax and also collecting by the UF user charges.
Where have you given an explanation? Let's read your petition. Where is the explanation of the delay in approaching the court? Where is it? And how is it public interest litigation? You are...
Rather, it is against the public because by virtue...
No. How is it a public interest litigation? This is a private hospital association. It is a relief for yourself, correct? You are seeking relief for yourself.
No, my lordship. For the benefit of all hospitals and also public.
That's right. Only for hospitals.
Yes.
It's not for the public.
Yes.
See, it's a relief being sought by the hospitals for the hospitals. Who is petition number 2?
The secretary.
Secretary of the
association. You should describe that. You don't.
He has mentioned it in the cost title.
No, it simply says Anand Prasad Rautri, son of so and so. He has not described himself as
that in serial number 1, General Secretary Anand Prasad Rautri.
Okay. Anyway, where is the explanation of the delay? Which paragraph have you explained the delay? So did you draft this petition or somebody drafted it?
No, my lordship, I am drafting this.
Sorry? Who drafted this petition?
Myself.
So you should know why he has to help you. If you draft, you should be immediately coming down to that paragraph.
Not mentioned the delay.
You didn't think there is any delay. In 2023, you're filing a petition challenging 2016 regulation, correct?
No.
First question that should come to your mind is, what were you doing for 7 years? What are you, sir? You are the briefing counsel or?
No, my lords.
No, my lord, we are both are.
You're together. So neither of you thought of this. You didn't expect court will ask you these questions. And why is it a PIL? How is it a PIL, sir?
My lordship, one time taxes collecting from the municipal.
You answer the question first, and then you can answer whatever you think you want to answer. You answer first the court's question, then you can say whatever you want.
Rather, the impugned regulation is for the benefit of the public.
I know. So obviously, it is a self-interest petition. It's not public interest.
It is apparent on the face of the record.
the counsel with the petitioners is unable to explain how this petition could be termed as a public interest litigation when
My lordship,
the petitioners are a private association of hospitals. Petitioner number one is an association of private hospitals, with petition number two being the general secretary of the association, and the relief being sought is exclusively for the benefit of the petitioners and not for the general public. Full stop. Therefore, this petition cannot be termed as a PIL. Paragraph secondly, petitioners are unable to explain they are challenging in 2023 a regulation of 2016. Full stop. The petition is silent. The arguments in the petition also do not offer any explanation for this delay. Paragraph. Permitting the petitioners to file a supplementary affidavit to explain the delay before the next date. The court directs that this petition be not numbered as a PIL petition. No, not be treated as a PIL petition. No, not be numbered as a PIL petition, but as an ordinary writ petition, and be listed before the roster bench on 11th May 2023.
Item number 2. My lord, I am challenging inaction of the OP number 3, my lord, who is not initiating any proceeding against the government land and causes OP number 4 and 5. In spite of our request, my lord, in our last request made by the said OP number 3 on 16th March 2023 at page 30, my lord, through registered post.
All right. The petitioner's representation, bracket extra 3, will be examined by the Tahsildar, Khaira, and after notice the petitioners and opposite parties 4 and 5, and after giving them a hearing, the reasoned order should be passed not later than 1st July 2023, and be made available to the parties within a week thereafter. The court clarifies it is not excluded.
Item number 3.
may I please, your lordships? My lord, other similar matters are posted to 22nd of June, my lord.
What is that other similar matters of the
Other-
same appellant?
Same appellant, my lord.
All right. List along with
Along with WA 54 of 2023 and 57 of 2023
54 and 57 of 2023 on
22nd of June.
22nd June 2023. All right.
Another matter is also there, my lord, in the list, my lord. Item 53, my lord.
Okay.
53 also.
Same order.
My lord, same.
All right. All right.
Item number 4.
My lord, in this honorable court, I have challenged the order of learned single judge dated 1/2021 under annexure 7 at page number 77 of writ appeal. My lord, that order was passed before admission of my writ petition in the same bench. And that was almost an interim order, direct me to vacate the railway quarters, which was under my occupation, and that vacation arose due to unlawful removal of my service when I was under treatment at SB Nether Olodpur Cuttack for replacement of my artificial limb. My lord, I am a physically challenged person and I lost my right leg below knee in course of my duty in railway. And that removal was without serving me inquiry report, and still now I have not received inquiry report. And my main case is also today listed in another single bench of this honorable court. Another division bench of this court, the honorable court, against the order of CAT. And today is hearing fixed. And I am in this court, I have requested for a continuation by railway quarter. Until now, I am residing in railway quarter from last
How can you-
2013.
No, 2 or 3 things. Today, what is your age, sir?
My aim is I am residing in railway quarter.
1 minute. 1 minute.
My age is 63, my lord.
Can you continue as a railway
No,
servant?
my lord, I have been terminated since 2000.
No, I'm asking you, since you seem to be quite well versed,
Yes.
suppose you succeed in that litigation.
Yes, yes.
They'll put you back in service.
No, my lord.
They will not, no?
Yes.
So can you continue without being a railway employee? Can you continue in quarters?
My lord, I cannot continue, but my lord, I was
What is the date of this order? The single
of-
judge's order?
1/2/2021.
That is 2 years ago.
Yes, yes,
So
my
despite this order, you have continued.
my lord, I am still under sick list, and there is a railway circular that when a person is under sick list, he cannot be
So
removed.
even if we today dismiss your appeal, you will anyway not vacate.
Yes, my lord.
Ah,
My
so
lord,
very-
my
such a convenient thing, sir. Why are we wasting our time then?
my lord, my side, I am staying.
You see,
because-
you're already 63 years old. When were you removed from service?
My lord, I admit I am.
No,
63
let's,
years old.
before you admit, we'll just know the facts, sir. We should know the facts, no?
My lord, although I have been removed,
When were you removed, sir?
my lord, I was removed and subsequently
No, date. When were you removed from service?
15/10/2012.
2012.
Yes, ma'am.
So 11 years ago.
My lord, that removal has been again reduced to compulsory retirement
Ah.
against.
It's okay. Compulsory retirement means also you cannot continue.
My lord, that is also gone. Compulsory retirement is not also valid today. And
Ah.
the order of single bench and the order of.
So when do you propose to vacate? You are now 63 years old. When do you propose to
My
vacate?
lord, last 10 years I am not getting any salary nor pension.
So your you will not vacate then.
When that will be cleared, I will vacate.
When will it be cleared? Whenever. When you are 75 years old, if it's cleared, you will vacate
My
then.
lord, today hearing is there in the.
Okay, today nothing happens. Simply adjourn.
Well,
You will not vacate.
If 2-3 months it will be cleared, I will vacate.
If it is not cleared, you will not vacate.
No, my lord, I will vacate.
When?
How shall
Which is the good day? Which is the good day for vacating?
My lord, where shall you move?
So if you are not able to move anywhere, you will continue railway quarters.
My lord, I have no salary, I have no pension,
Correct.
nothing else.
Correct.
How I shall live, my lord?
So that's the law. If you do not have any of that, railway quarter is yours because one time you are a railway employee.
Further, my lord, another thing that quarter has will not be allotted to any other fellow.
You have already decided that.
My lord,
You have decided it will not get allotted to anyone.
no, my lord, I have not decided. Railway has decided.
That this is for you for life.
That is.
They have passed an order that this quarter is for you for life.
No, my lord, I will vacate. That will be dismantled.
Ah.
Not that will be allotted. That will be. I require for 2-3 months, my lord.
Ah.
When my case was last stage, and when it will be decided, and my.
Suppose the case is not decided, you will not vacate.
My lord, my pension is there, my
Correct.
discharge is there. My
So
everything-
irrespective, see, why do you need court orders, sir? Because single judge said he did not agree with you,
That's-
which is why you're in appeal.
My lord,
Single judge did not agree with you, which is why you're in appeal.
no, my lord, notice has not been served on merit. It has
No,
not
did
been-
single judge agree with you or disagree with you?
No, in the admission charge, he directed me to vacate.
That was 2 years ago.
Yes,
And you did not vacate.
my lord, there is no alternative. What
No, so why do you need court order? See,
My lord, there is-
even if the court says vacate, you're not vacating, no?
My lord, there is no alternative.
Correct. So I'm saying, despite court asking you to vacate, you don't vacate.
Okay.
Railways asking you to vacate, you don't vacate. Why do you need court order? You have yourself decided. Sir, till cases are decided, I'm not vacating.
No, my
Whether an order is against me, in my favor, you're saying no problem, sir. I will
Yes,
simply continue.
my lord, there is.
Why do you need court orders, sir? You don't need court orders.
No, my lord, there is also rules there.
No, sir, I'm just saying, sir, today we dismiss the appeal.
my lord.
You will say, where should I go? I will continue.
No, my lord, it is only for use force, I will be bound to vacate.
How? You've decided. See, you said just now that till my cases are decided, I will not vacate. You just now told us.
My lord, I have also cited one case of Honorable Supreme Court.
Which
One
says that despite losing in all courts, railway employee, ex-railway employee does not vacate. That's what Supreme Court said.
No, my lord,
Ah.
one I just at the Isapriya Bhatia versus Union of India.
What does it
In
say?
that case, 12 years he was terminated in the year 2012.
Hmm.
And finally, his litigation was over in 2020.
Hmm.
And he was again given 3 months time to vacate the quarter.
Hmm.
And my case is still in my favor, not against me. My case on merit is still in my favor.
Courts have, you have already decided. Since you are very clear it is in your favor, why do you need court orders, sir?
My lord, I have enclosed court here. My lord, page 7, I must say. Page number 37, my lord.
Yes.
That is one observation of learned single bench of East Honorable High Court.
Yes.
Considering the rival contentions of the parties, this court finds though the writ petition involves order of disciplinary authority, appellate authority, reviewing authority, and also at the higher level subsequent to the disposal of a division and review, but the petitioner's approach against the order of punishment and the reduction and confirmation thereof by the higher authorities to the State Commissioner Orissa, Bhubaneswar, or the provisions of PW Act referred to herein the Bhubaneswar, and the decision of the State Commissioner Orissa, Bhubaneswar at Annexure 30. This court finds there is no adjudication of the proceeding involving the petitioner as of now by any competent authority,
Right.
except the State Commissioner deciding that the proceeding initiated involving the disciplinary proceeding concerning the petitioner was not maintainable before the State Commissioner.
No.
That means, my
What
lord,
what we are concerning now
My lord.
is not your compulsory retirement, right? That is a separate proceeding.
well, my lord, that is in this honorable court.
I know, it is in some other court, no? sir?
Yes, yes,
It's not in this court. It is in this matter. So this decision you should be citing in that case, correct?
No, my lord,
No.
I only want
No, this decision you will not cite in that other court.
No, this
Why?
is separate. My lord,
No, when that case is called out, you will not cite this judgment.
my lord, this is quarter matter, that is service.
This,
matter.
what you read out is a quarter judgment.
This is-
What paragraph you read out is about quarters.
No.
Ah, so this paragraph you should be reading out in
my
that
merit-
case.
In my merit, my lord.
So that has nothing to do with this case today here.
Again, my lord, in the merit, the honorable State Commissioner, my lord, page number 68, my lord.
Yes.
These are
You give us a simple answer today when we dismiss your writ appeal. If we dismiss your writ appeal,
My lord.
will you vacate or you will not vacate?
my lord, if they will immediately use force and I will be vacated. I will go to road. There is no alternative.
Sorry.
If they will use force, then there is no.
No, Christopher, they will use force and all. They never used force against you for the last 2 years.
Yes, my lord. When this was no honor stay, my lord. I was not illegally retaining. Honorable district judge given stay for entire period, my lord.
District judge gave you stay.
Yes, my lord.
No, after single judge dismissed your writ petition, district judge gave you stay.
No, lord, no, my lord. I came to this court after dismissal of district judge Sambalpur for retention by quarter. That is a recent proceeding.
And then when did this court dismiss your writ petition?
My lord, writ petition is still pending, not decided, my lord. Only interim order I was directed to vacate. And now the writ petition is still pending. That is
So interim order was passed when, you tell us?
1-2, my lord. Annexure 7, my lord.
What is the date, sir?
1-2-2021.
After that, they used force against you?
No, my lord. Since the case is under sub judice, they have not been reported. And beforehand, force was used. Everything is there, my lord.
No. So they did not use force against you.
My lord, that liberty will be given, and I will.
No. Last 2 years, they did not use force against you.
No, my lord. Since the case is under sub judice, my lord.
Sorry?
Sub judice, my lord.
So they also decided with sub judice, despite dismissal of your application, they will not vacate you.
Moreover, my lord, that quarter will not be allowed.
Which is why I'm saying, sir, why do you need us? See, you seem to be very comfortable now. You're right now residing there, no?
My lord, I am deciding.
And you have no plans to vacate.
Yes, my lord, I will vacate. I will.
When will you vacate, sir? When will you vacate?
There is no alternative for that reason I am deciding.
No. See, you will only tell them.
My lord, there
See,
is no
despite your applications being dismissed,
My lord,
you're able to convince them that because your writ petition is pending, you do not have to vacate.
for that in there is
Same
no
thing.
authority,
I'm
my
sure when they ask you, you say, no, it is sub judice.
lord. My
They
lord.
seem to agree with you. Despite your single judge saying that you have to vacate, you have not vacated.
Yes, no, my lord.
So they are
there
also,
is no authority.
your railways are also very kind to you.
Yes,
So what I'm saying is, this is irrespective of court orders.
yeah, my lord, they will release my salary, they will release my pension, they will release my discharge, then I will vacate, my lord.
That's what, you have so many conditions, sir. So you have very clear in your mind, till so many things happen, you will not vacate.
No, my lord, nothing happened.
Correct, that's what we are also telling. Nothing has happened to you. You're comfortable.
No, my lord, I am staying.
Yes, that's what. You're staying there comfortably, sir. See, railway asked you to vacate, you did not vacate. Single judge asked you to vacate 2 years ago, you did not vacate. You're staying comfortably there. That's what. I'm just saying. So when you're comfortably there, you don't need court orders.
I am waiting for court order, my lord.
See, whenever you get negative court order, you do not obey.
Then there is no alternative.
Correct. No, not obeying is not. See, according to you, there's no alternative but to disobey.
No, my lord, liberty may be given for 3 to 4
Liberty, more liberty only for what?
My lord,
They can give you liberty to obey the order.
I will make arrangement, my lord.
We'll give you liberty to obey the order. You want that liberty, we'll give you. liberty to obey the order. So far, you have not obeyed any order. Railway order, you did not obey. District judge order, you did not obey. Single judge order, you did not obey. So now what liberty? Liberty only to obey.
My lord, my
We
sahib
give you full liberty to obey all these orders.
my lord, my sahib is matter. Railway not to obey order.
That's what. They will not obey, you will not obey, then what is the problem? No problem. Why do we need courts, sir? See, unnecessarily one court, district court wanted you to vacate. Single judge wanted you to vacate. You never vacated. Before that, railways wanted you to vacate. So we'll give you liberty to obey the orders now. So far, you have not obeyed. Correct?
My lord, there is no alternative. How shall you obey? My lord, I have to leave somewhere.
See, you will obey. You are saying I will obey, sir. Whenever it's convenient to me, I will obey you. Sir.
Railway, there is provision for.
Whenever I decide I want to obey, I will obey you. Sir.
My lord, there is order for in the railway rules for retaining my DCIG.
Yes.
But everything is pending, my lord. Since case is under sub judice.
So we'll have one less pending now. Today, now we'll dismiss this appeal. One less pending. Railways are very kind to you. Let them continue to be kind. That's the best way to do it. You say, despite the learned single judge dismissing.
Well, liberty may be given to get this issue in the single bench again. The case is pending, my lord.
Repetition? I don't know.
Case is still pending in a single bench.
Huh?
So, VPC 3 to answer.
Never listed after that. Despite date being given. Never got listed after that. So the state officers matter. We ordered it. 1st February 2021, passed by the single judge. Purportedly dismissing IA number 1590 to 2021 in writ petition civil 3213 of 2021, declining to stay an order dated 22nd July 2013, passed by the State Officer, East Coast Railway, Sambalpur, requiring the, under Section 5(1) of the Public Premises, Eviction of Unauthorized Occupants Act 1971, PPE Act, requiring the appellant, who at that relevant time was a railway employee, to vacate railway quarter number AC by 17/1, type 2, at Sector D, Railway Colony, Sambalpur. Full stop. The learned single judge also declined to stay the operation of the appellate order dated 19 January 2021, passed by the District Judge Sambalpur in FAO number 13 of 2013, which dismissed the appeal filed by the present appellant against the eviction order passed by the estate officer. Paragraph. When the writ petition was listed first for hearing before the learned single judge on 1st February 2021. It was noticed that despite being removed from service, the appellant continued to be in occupation of the railway quarter in his favor. Full stop. The learned single judge observed open petition, even if he is no more in service and his service period has expired, he is forcefully occupying the quarter, full stop, therefore is liable to vacate the quarter, full stop, unquote. The above observation came about since the appellant was, even at the time of filing the writ petition, 61 years old. Full stop. He had been removed from service by an order dated 15th October 2012. Full stop. Therefore, by the time the matter was heard before the learned single judge, he had already ceased to be in service for approximately for over 8 years, and without any order in his favor in the separate proceedings in which he had challenged his removal from service, he continued to occupy the railway quarter. This prompted the learned single judge by his order dated 1st February 2021 to direct the appellant to vacate the quarter by 28th February 2021, open quotation, failing which contempt proceedings shall be initiated against him for non-compliance with the order of the court. Paragraph. The learned single judge directed the case to be listed on 3rd March 2021. Paragraph. Although on the reading of the order, it is plain that it is IA number 1590 of 2021, which has been dismissed by the learned single judge, there is no mention of the said IA in the said impugned order. Paragraph. Be that as it may, from the record, it appears that the writ petition was listed again on 8 March 2021 when the court was informed that the present writ appeal had been filed by the appellant. Paragraph. A perusal of the present writ appeal reveals that the appeal was filed on 27th January 2021. Sorry, was filed on 12th February 2021. Full stop. On 8 March 2021, the learned single judge directed that writ petition civil 3213 of 2021 should be listed after the disposal of the present writ appeal. Paragraph. The present writ appeal has never been listed before the court till today, when it has been taken up in its usual course. Full stop. In other words, there has been no stay of the order of the learned single judge, which required the appellant to vacate the premises under his occupation. Paragraph. The appellant today is admittedly over 63 years old. Full stop. In response to a query whether he has obeyed the order of the learned single judge, the appellant answered in the negative. Full stop. When asked how he could justify not complying with any of the orders which were against him and continue to occupy the railway quarters despite having crossed the age of superannuation, the appellant simply answered that till such time the petition filed by him challenging the termination of his services is decided, he does not propose to vacate the quarter under his occupation. Full stop. In other words, the appellant is not considering the orders so far passed either by the estate officer or by the district judge or by the learned single judge as requiring him to vacate the quarters and his occupation. Full stop. It appears that the respondent railways has also not made any move against him, as disclosed by him before this court, to require him to vacate the quarters. Paragraph. In the circumstances, the court sees no justification for interfering with the impugned order of the learned single judge, while only observing that the continued occupation of the appellant of the quarters despite ceasing to be a railway employee for over 10 years now, appears to be wholly unjustified. Stop. The writ appeal is accordingly dismissed. No, but don't call it because therefore this will be continued. Writ petition civil 3213 of 2021 will now be listed before the learned single judge in the Orissa bench on 1st May 2023.
Item number 5.
May please, Your Lordship. Your Lordship, in the present matter, the present appellant has challenged the order passed by Honorable Single Judge in dated 15/7/2022, Your Lordship. That is at Annexure 8, page 53, Your Lordship. Your Lordship, the facts leading to the present writ appeal is that the present appellant had been selected as a successful Anganwadi worker earlier for the block of Chandamunda block of Binjarpur, Your Lordship. Thereafter, Your Lordship, the present opposite party number 5 has filed a Anganwadi miscase appeal before the opposite party number 2, that is at page number 6, Your Lordship. Annexure 6, page number 49, Your Lordship. The appeal was filed on the ground that despite the submission of the mark sheet, Your Lordship, of the 10th mark sheet, the opposite parties had not considered her candidature for the Anganwadi worker, Your Lordship. The learned opposite party number 2 was pleased to upheld that the submission of matriculation certificate is not necessary and a mere mark sheet that has been issued by the headmaster will suffice, and the scrutiny committee had erred in rejecting her application, and that is why the present opposite party number 5 will be eligible for the said post, Your Lordship. Challenging the order of the opposite party number 2, Your Lordship, the present appellant had also approached this honorable court, Your Lordship. Your Lordship, the requirements of the eligibility criteria is there at page number 18, Your Lordship. Your Lordship, page number 18, it has been stipulated that the documents have to be submitted within the stipulated date, that is 26/7/2017, and the same cannot be accepted later on, Your Lordship. While the opposite party number 5, Your Lordship, before the scrutiny committee, she did not submit any matriculation certificate. She did not submit her original documents, Your Lordship.
No, she submitted her attested mark sheet.
Yes, Your Lordship, but the requirement was not that of attested mark sheet. The requirement was that of submission of matriculation certificate, Your Lordship.
Let's read that. What the single judge says.
Your Lordship, that is at page 20, Your Lordship.
No, I think the operative portion is para 26.
Yes, Your Lordship. Your Lordship, the stipulation of advertisement was submission of the matriculation mark sheet, Your Lordship, and that is to be
Why don't you read para 26 of the single judge?
As per the norms of selection of Anganwadi, the marks secured in the matriculation is of primary consideration, Your Lordship. On perusal of the materials on record, it is seen that admittedly the opposite party number 5 is more meritorious than the petitioner, and this court is persuaded to hold that the mark sheet submitted by the opposite party number 5, which were issued by the headmaster of the school, confirms the stipulation of the advertisement relating to submission of photostat copy of the mark sheet, Your Lordship. The selection committee, in rejecting her candidature, has virtually rewritten the stipulations relating to the submission of mark sheet to be submitted, which is expressly not permissible, Your Lordship.
So what did the selection committee do? Where is that order?
Your Lordship, the order of the selection committee is at page number 34, Your Lordship. 34 of the brief, Your Lordship.
Right.
Your Lordship, para 5, Your Lordship. third last para from the bottom, para 5, Your Lordship, page number 34. Your Lordship, the last line says, Ranjita Pradhan's application, the present opposite party number 5, was rejected due to the non-attachment of HAC board mark sheet to her application, Your Lordship.
Why is that this HSC board mark sheet is not correct, right? In the sense she did attach a photostat mark sheet attested.
No, Your Lordship, she did not attach a photostat even. She simply gave a handwritten mark sheet that has been written by the headmaster and signed by the headmaster, Your Lordship.
No, that is whatever they give her, she has to attach. I say she can't dictate to the headmaster, you better type it out.
Your Lordship, the same has been, she had submitted a mark sheet that had been virtually written by the headmaster saying that
Virtually meaning what? He imagined the marks on his own?
No, Your Lordship, the marks are the same as that of what she has scored, Your Lordship.
No. So you're not disputing that she scored those marks.
No, Your Lordship.
So don't say you're making it appear as if the headmaster thought of some marks and simply handed out some marks.
No, Your Lordship, that is not the case.
So you're not even challenging the genuineness of the mark sheet. You're not challenging the fact that she scored much higher marks than you did.
Yes, Your Lordship.
So what is the justification for rejecting?
Your Lordship, when the mark sheet that has been submitted by her, Your Lordship, if that is given into effect, Your Lordship, then that is directly violating my right under Article 14
She
and
scored
16.
higher marks than you. Where's the violating your
Your
right?
Lordship, but then there's the
Denying her would be violating her right. Correct? When she scored higher marks than you.
Your Lordship, but there's a certain procedure that needs to be followed. And
What is that procedure aimed at?
that procedure is
To
submission.
find out who is the more meritorious candidate. Any selection, that's the aim of the
sir.
selection.
Yes,
Correct. So,
Your Lordship, but then there's a mode of submission of the documents also, and certain documents authorized by
if it impinges on the genuineness of the document, suppose the original reads that she's got only 20 marks, what she has submitted shows she scored 40 marks.
Your Lordship,
Then you can say the copy does not match the original, you have to reject the copy.
Your Lordship, but she was given that 7 days time to produce her original mark sheet also. So the whole point of having a scrutiny committee is, while applying whatever documents you are submitting, when you are producing the original documents, the scrutiny committee will compare the same and verify your candidature, Your Lordship. But in non-submission of the original certificate at that very particular time also, Your Lordship, the scrutiny committee has
No, did she submit the original at all or she?
No, Your Lordship, she did not submit the original at all. She has rather submitted her +2 certificate. She has never submitted her matriculation certificate, even at the time of final verification.
Let's read the order of the appellate authority.
Yes, Your Lordship. Lordship, parrot 20 is the
No, page, I think the running page is 49.
yes, gone through the
There is a paragraph which says the short history.
history of it. The short history of the appeal is that the appellant, during filing of her application for the post of Anganwadi worker in Chandamunda Anganwadi Center, has filed mark sheet of matriculation issued by the headmaster Sri Jagannath Vidya Mandir Rahasoi instead of the board. But on the date of verification of original certificate of the candidate, she has filed the original board mark sheet certificate having the same mark
So
as
you gave us a wrong answer.
Your Lordship, but
On the date of verification, she did produce the original certificate.
No,
You
Your
said she
Lordship.
never produced the original. That's what you just saw submitted.
yes, Your Lordship, because in the counter that has been
No. This is the order.
yes, Your Lordship, this is despite the fact that even the opposite party number 1, that is the CDPO, Your Lordship, he has submitted that the Council of Secondary Education relates to +2 marks, Your Lordship, but she has never submitted her board. That is the recording in the scrutiny committee
No.
documents
But
also.
you are. When we asked you, did she produce the original? You said no. She never produced any original, which is a wrong statement.
Your Lordship, that is what is.
Why do you make a wrong statement? The sense is obvious that she
I may
produced
be-
an original.
I may be pardoned, Your Lordship, but in the proceedings of the meetings of the committee.
No. This is what we're reading from the order. Continue reading. So
Yes,
she
sir.
did produce verification of the original certificate. She has filed the original board mark sheet certificate. Read
But-
that.
In response to the notice, which has not been considered by the selection committee, taking plea that she has not filed the copy of the original mark sheet of the board during filing of her application.
Application.
Your Lordship, this is the contention of the
Read on.
Though she has been secured 483 marks, the selection committee selected the respondent who has secured only 230 marks. In response to the notices, the learned advocate for the respondent number 1 filed written statements wherein he stated that the appellant has not filed the copy of the original board mark sheet during filing of her application and for verification of her original board mark sheet, by which she has not been selected by the selection committee. The CDPO Binjarpur as respondent number 1 has also submitted her written statement with documents and the Anganwadi workers marks calculation sheet of Chandamunda 3 Anganwadi Center, wherein it is stated that the appellant has not attached the original board mark sheet.
Attaching is one thing. What she attached with her application was the photocopy. But at the time of verification, she produced the original.
Your Lordship, it is the first paragraph.
This is one hyper-technical thing that, you should have attached the original with your application.
No, Your Lordship, that is
What
not.
the advertisement requires is only a attested photocopy to be attached. So during the time of verification, she produces the original. And you say, no, with your application, you did not attach it and therefore we are rejecting.
Your Lordship, but that is the thing, Your Lordship. In the time of verification also, the CDPO itself has given a written statement that the original certificates
No,
were
he
not
did
ready.
consider. See, she produced it. He does not consider it, saying you did not produce it along with your application.
And also, Your Lordship, thereafter also after.
In fact, this is a classic case where you simply throw it out on a hyper technicality, despite knowing that this is not one forged certificate, this is not a fabricated document.
Your Lordship, but her board certificates also have never gotten into record, Your Lordship.
No, you don't take it on record. What is this brought on record? At the time of verification, you produce the original, you say, no, I will not consider
Your
it.
Lordship, that is what is the stand of the CDPO, Your Lordship.
Yes, which is what is wrong, which is what is being challenged.
Yes, Your Lordship, but that.
How is it justified? The CDPO, how can he throw it when the original is being produced? He says, I won't look into it.
Your Lordship, but in the original certificate also, they have produced the certificate of Council of Secondary Education, Your Lordship. That is of +2.
Produce whichever is the exam you took.
Your Lordship, but that was supposed to be the Board of Secondary Education certificate, Your Lordship.
That's not what the advertisement says. That doesn't, in fact, the single judge correctly points out, it does not stipulate that it has to be this board or that board or anything.
Your Lordship, that is what is the difference. Board of Secondary Education
No.
relates to 10th standard, Your Lordship, and
Or.
Council of Secondary Education relates to +2, Your Lordship.
Or
Your Lordship, and in the advertisement also, it has been stipulated that it is the matriculation certificate that needs to be taken care of.
correct.
But here the matriculation certificate, instead of matriculation
She
certificate,
has passed the matriculation, madam. You're not able to overcome that fact. She has
Your
gotten far more marks than you have.
Your Lordship,
This is the problem.
that is what is the contention. Then she
Yes,
should have
yes.
submitted the original certificate.
It's all
Your
a
Lordship.
hyper-technicality. You say the challenge in the present writ appeal is to an order dated 15 July 2022 passed by the learned single judge, allowing writ petition civil 4518 of 2019 filed by respondent number 5, whereby she had questioned the selection of the present appellate as Anganwadi worker bracket AWW of the Chandamunda Anganwadi Center bracket AWC pursuant to an advertisement issued on 27 June 2017. Paragraph. The selection of the present appellant had been assailed by respondent 5 in an appeal filed before the Additional District Magistrate bracket ADM, which came to be dismissed by an order dated
15/7.
no, which came to be allowed. Sorry. By an order dated 13 February 2019. You got to stay in the writ petition.
Your Lordship.
When the writ petition was filed, did you get a stay in your favor?
No, Your Lordship. There was no stay.
So you've been out of service since then?
Yes, Your Lordship.
I see. The learned ADM noted in the impute in the said order that the selection committee had wrongly failed to consider the original mark sheet, matriculation mark sheet produced by respondent 5 at the time of verification, only because she had not enclosed it with her application. Full stop. Admittedly, respondent 5 scored 483 marks in her matriculation, whereas the present appellant scored only 230 marks. Full stop. Holding that the selection committee fell in error in not allowing respondent 5 and not considering the original board mark sheet submitted by respondent 5 during verification. The ADM set aside the orders engaging the present appellant and directed that appropriate orders should be passed by the selection committee as regards engagement of respondent 5. Paragraph. In the writ petition filed by the present appellant, it was again urged that respondent 5 ought to have produced the original mark sheet along with her application. Stop. It was also sought to be contended that the mark sheet submitted at the stage of verification was at variance with the original mark sheet and therefore could not have been considered. Okay. Paragraph. The learned single judge noted that the requirement of the advertisement was single quotes matriculation certificate and mark list. Unquote. The revised guidelines required the production of the revised guidelines referred specifically to the marks secured in matriculation, which was the minimum educational qualification that was prescribed. Paragraph. The learned single judge found that the selection committee rejected the candidature of respondent 5, stating open quotation, no original board mark sheet attached on application, comma, rejected, unquote. Paragraph. The learned single judge found no merit in the contention of the appellant that since the mark list that was submitted was not issued by the Board of Secondary Education, Orissa, but prepared by the principal of the institution and signed by him, it could not have been considered. Full stop. The learned single judge noted that the stipulation regarding submission of documents did not require that the mark sheet has to be necessarily issued by the board, and therefore the selection committee had misinterpreted the stipulation. Full stop. In para 21, the learned single judge noted as under. Reproduce the whole of 21. Paragraph. In other words, what was issued by the headmaster, tallied with the mark sheet issued by the Board of Secondary Education, and there was no variance whatsoever. Paragraph. Learned counsel for the appellant. Reiterated the stand taken throughout, namely that respondent by ought to have produced the certificate, matriculation certificate, as well as the original mark sheet issued by the board along with the application. So, the court is unable to accept the above plea since factually it has been demonstrated that the copy of the mark sheet enclosed with the application tallied with the original which was submitted at the time of verification. Admittedly, respondent 5 is more meritorious going by the marks secured in the matriculation examination. More meritorious than the appellant going by the marks secured in the matriculation examination. In the circumstances, the court is unable to find any error having been committed by the learned single judge in dismissing the petition filed by the appellant. The appeal is accordingly dismissed.
Item number 6.
Lord, we have filed the counter affidavit. Lordship has directed unless it is filed, the 25,000 cost, we have filed it on time.
Yes, please. Do you want to file a rejoinder?